Hello, welcome to this exciting episode of the Law Show, where we talk nothing but law, cold, hard, but sweet to eat law for you. Today we have a beautiful program we're going to talk about, with a beautiful topic rather, with a very distinguished guest. We're looking at the problems between landlords and tenants. The problem between landlords and tenants, and fashioning out solutions, to those problems arising from questions that, many of the viewers have asked. So landlords and tenants. If you are a landlord, pay attention. If you are a tenant, you want to know your rights here now. And I've got with me in the studio my very, very learned senior colleague in the legal profession, a distinguished jurist, a distinguished public speaker, a distinguished author, a distinguished journalist, a distinguished community leader, and so on and so forth. His name is Miakpo Emiaso. I hope I pronounce it properly. Miakpo Emiaso. He has written, last time I checked, 5 books. 5. I've got here with me. The first one is Area Customary Courts in Nigeria, not in particular order of production, but just the first one my hand got to first. Area Customary Courts in Nigeria, Law, Practice, and Procedure for Lawyers. Okay. Another one here, Landlords and Tenants under Nigerian Laws, which we are going to talk about. That's the blue distinctive book. There's another one here, Cooperative Societies, Law and Practice in Nigeria. And there's another one, Forgiveness, A Sure Path to Peace and Joy. And I think so many people need all these books, and you particularly this one of forgiveness. So many people you need to learn how to forgive, and you need to also learn how to accept forgiveness. And then there's another one on how to recover the properties of dead relations. And so I could go on and on, but we've got him in the studio, Miakpo Emiaso, Esquire. You are welcome to the studio, sir.
My pleasure. I'm so happy to be here.
We are so glad to have you, landlords and tenants. What, sir, is the nature of landlords and tenants relationship? Lots of people think it's rather a master-servant relationship. You have a landlord, as is aptly called landlord, and you have a tenant who is like a servant. Does that capture it aptly, the relationship?
In practical terms, yes, that's what you find here in this country, because it's a matter of supply and demand, isn't it?
Yes.
If you have too many premises available for tenants to choose from, then the landlords are not going to be in a position to dictate anything, because the tenant will have choices to make.
Yes.
If he can't afford this one or doesn't like this one, he can. But we have a serious shortage of decent premises,
yes.
Decent houses for people to live in.
Yes.
So this is a country where people build houses with their individual personal finances.
Yes.
The mortgage system is not working effectively in this country.
Yes.
I know that in better environments,
yes,
it will be only somebody who is having some challenges upstairs that will use his hard-earned money to build a house. The normal thing is for you to get a mortgage. The mortgage bank will finance the building. You pay over time, and then you can then get tenants who pay. It's pure business. And that also explains the relationship between a landlord and a tenant. The relationship is contractual.
It's contractual.
It's a contractual thing.
Okay.
Both parties come together, they talk things over, they negotiate, they agree. this thing that these lawyers call consensus addendum is built into it.
Okay.
And then a contract comes into being.
So they have to agree the terms and conditions.
Yes,
for example,
exactly.
Rent, how much is paid as rent and over what period?
Exactly. It's just that.
Yes.
Because of the shortage of premises,
Available
of
accommodation,
houses,
you mean, okay.
that negotiation is one-sided.
One-sided, okay.
One-sided in the sense that whatever the landlord tells you,
yes,
that's, I mean, you really don't have much bargaining power.
So you've come, I want to rent your house. It's okay, this is the house. It's 2 million per annum. Take it or leave it.
Yes.
It's these are the conditions. Take it or leave it.
Yes, that's what you
then
find.
I'll say, okay,
yeah, that's what you find now.
I mean, honey, we have no other place to go anyway. We might as well just just take it. So,
but it shouldn't be that.
It shouldn't be that.
It shouldn't be
It
that
shouldn't
way.
be that
It should
way.
be something that both parties sit together, negotiate it, just like you buy your meat in the market.
Yes. Okay.
I sell my meat for 5 naira.
Yes.
Please, I don't have 5 naira. Can I give you 3 naira?
Okay.
They say, okay, bring 3 naira 50
okay.
kobo.
Okay.
No, that's how it should be. But because of the peculiarity of Nigeria, where everything, of course, is in short supply, including everything in Nigeria is short supply, except perhaps free air.
No, except politicians. Let me just ask this question that is just running around my mind. Now, if the relationship between landlord and tenant is contractual, they have to agree. So, which means they also have to agree length of the tenancy, the period of the tenancy, and if the tenant has to leave, what kind of notice the landlord should give, all that. Now, that will be embodied in a contract, tenancy agreement. Where there is no tenancy agreement, what happens, sir? Because there are many people who don't have tenancy agreement. You want to rent a place, give me the money, that's the key, boom, you are in.
No, but there is an agreement. What you mean, perhaps, is that the agreement is not written.
It's not written, yes.
Okay.
So well, what happens if there's a dispute?
You are correct that most landlord and tenant relationships are not reduced into writing, but that relationship is regulated by law.
Okay.
In every state of this country, there is a recovery of residential premises law,
Okay.
which spells out how a tenant becomes a tenant,
yes,
and what his rights are. And okay, now there are basically 2 types of tenancies in this respect. Most tenancies are periodic tenancies.
Most
That
are
is,
periodic
yes,
tenancies.
they are periodic tenancies and usually 1 month periods.
Okay.
So they run from month to month.
Okay.
And these tenants pay their rents on a monthly basis. And then there are tenants who come in as tenants for a fixed period, a fixed duration of time.
Okay.
The law describes most of those kind of contracts as leases.
Okay.
So a tenant moves into a premises and says, I'm going to be here for 5 years.
Okay.
So both parties drop a lease agreement.
So that's a 5-year lease.
For 5-year lease.
Yes.
And it's reduced into writing, which they sign.
Yes.
In Lagos State, irrespective of the kind of tenancy now, there must be a written agreement now. It is mandatory
For all tenancies.
Yes. But that is not applicable in other parts of the country. So most tenancies are just agreements in substance without necessarily reducing them to. Now, so if a contract is reduced into writing, usually these agreements are drawn by lawyers.
Yes.
And in the agreement, there will be specifications as to how the contract can be brought to an end.
Okay.
How long a notice a tenant will be entitled to should the landlord want to recover his premises and all of that.
Yes.
But the law provides that in the absence of that kind of written agreement, which is entered into deliberately by both parties, the law regulates the relationship. The Recovery of Residential Premises Law makes provisions for how long a notice a tenant is entitled to. Depending on the kind of tenant he is.
So let's look at the kind of tenancies now that are widespread, available. One, you have monthly tenancies. So if a tenant is a monthly tenant, what kind of notice, to quit should he get?
For a monthly tenant, the law provides that he is entitled to a 30 days notice to quit.
30 days notice. So 1 month notice requires 30 days notice. Then we have, though the law provides that, but we don't really have it, 6 months, nobody rents a property.
In Lagos State now you have 6 months tenants. Because Lagos State enacted a new tenancy law in 2011, I think, which now makes provisions for a 6 monthly tenant. Otherwise, before then, and in other states, including my state in Delta State, you don't have a 6 monthly tenant. But that does not mean that in practice you don't have tenants who pay their rents 6 months.
Every 6 months, but that's negotiated.
Yes, when they pay 6 monthly, apart from Lagos State now, there is usually that argument as to how long should a 6 monthly tenant get notice. Well, how long a notice should he get when the landlord wants to recover possession? But generally, it is assumed that a 6 monthly tenant is entitled to 6 months notice to quit. So just like a yearly tenant too. A yearly tenant is entitled to a 6 months notice to quit. And most times, yearly tenants they operate like leases. They operate like leases in that there is a written agreement in which parties have agreed that at the end of the year the tenancy will come to a close.
So now we need to clarify this. If you are watching, monthly tenant, landlord needs to give 1 month notice, 30 days. Monthly tenant.
There is a proviso.
I know, sir, but I just wanted to clarify this point. We'll come to the proviso. So if you are a monthly tenant, you pay your rent at the end of every month, landlord must give you 30 days notice to quit. That if you are a yearly tenant, which is usually prevalent, either you are 1 month or you are yearly, you pay your rent yearly. So you are entitled to 6 months notice to quit.
Exactly. Yes.
You said there was a proviso.
No, yes, there's a proviso to the monthly tenant. If a tenant pays his rent monthly, like we just said, he will be entitled to 30 days notice to quit. Anytime the landlord wants to recover possession of the premises. But if the tenant's rent falls into arrears for up to 3 months, the tenant ceases to be a tenant. The contract between him and the landlord is at an end. By the 4th month, he ceases to be a tenant. He is now like a trespasser who has trespassed on the land or the premises of another person. Because he has no contract, he has no agreement to be there. The contract which he entered into had come to an end, and ordinarily he should give up possession. But where he fails to give up possession and he remains there, he no longer he is no longer entitled to be called a tenant. So the rights of tenants, he no longer enjoys those rights. He is a trespasser of a kind, a special kind of trespasser, which is liable to pay a special kind of damages, not the kind of general damages that a usual trespasser will be liable to. This kind of trespass being special, having arisen from a pre-existing contract, the law describes that as mean profits.
Means profit.
Yes. That is because the law does not have an arrangement for anybody to live in the house of another one for free. When you live in the house of another person based on a contract,
yes,
you will pay rent. When you live in the house of another person without a contract,
yes,
that is after the contract that put you there in the first place has run out,
yes,
you continue to pay. But what you pay, because you are no longer a tenant, the law does not call it rent.
Okay.
The law calls it main profits.
Okay.
I know that there is a misunderstanding of this arrangement by a lot of people who now think that, I hear it being said that once a landlord issues a tenant,
that's the question I was going to ask. If the landlord has issued a quick notice,
yes,
some people feel, should they still pay anything? Should they pay rent to the landlord? After all, he has given me quick notice.
Well,
he has told me to use the remaining period to look for a house. And even if it takes me 2 years to get a house, I'm not paying him anything.
No, that's not what it means.
Okay.
That is not what it means. But that is what the ordinary man out there understands it to be. That once he's been issued with a quick notice, then he is not liable anymore to pay rent for as long as he remains there until he gets an alternative accommodation. That is not it at all. The only thing that happens is that because you've been given a notice to quit,
yes,
upon the maturity of that notice to quit, you cease to be a tenant, and only tenants pay rent.
Okay.
If you are not a tenant, you don't pay rent.
Okay.
If you pay for occupying premises, what you pay is no longer rent. It's called main profits, which is an arrangement in law that allows the owner of the house, because the moment he has given you that notice to quit,
yes,
he too ceases to be a landlord over you.
Okay.
He is now known in law as owner.
Owner of the house.
Yes, he is now the owner of the house.
Okay.
Who is now unlawfully, quote and unquote, unlawfully occupied by another person.
Okay.
Yes, but the law will still require that for so long as that person is in possession of that premises, he must pay.
You must pay
For occupation of that premises up to the very last second that he stays there. So, but because he's not any longer a tenant,
yes,
and he is no longer paying rent,
yes,
whatever he pays is known as mean profit.
Means profit. But he must still pay nevertheless.
He must pay. He must pay. He must pay something.
So there is no point in saying.
You can't
so I hope you are watching and you are hearing. If your landlord has given you quick notice, don't say, "I'm not going to pay anything anymore." You have heard from the master now, not the horse's mouth, the master's mouth, that you continue to pay until you actually physically, evacuate from the property. You can't stay in somebody's house without paying rent.
Except the landlord, on his own volition, decides to let you go with the money.
Says, okay, you can stay for free.
Yes.
But what about when the tenant says, okay, thank you, sir, you have given me quick notice. I'm looking for accommodation. I haven't found accommodation. In the interim, can I keep paying you rent while I'm looking? I've got the notice, I'm looking. But in the interim, can I keep paying rent? And the landlord says, Banaso, I don't want it.
No, it will not. Such a landlord is not a good businessman.
It's not a good businessman.
It's not a good businessman because if the tenant tenders money,
yes,
the landlord should collect it.
Okay.
That does not bring the notice to quit to an end.
Okay.
The notice to quit which he has served is still operational.
Okay.
Unless he decides or changes his mind. Okay? What we are saying is that whatever the tenant pays,
yes,
after a notice to quit has matured,
yes,
is not called rent. It is called mean profits.
Mean profit.
And mean profits are usually the same amount that the tenant was paying as rent.
The same amount?
Yes.
Okay.
It doesn't have to be.
Except that the name changes.
Yes. It doesn't have to be the same amount. But most times,
yes,
it is the same amount that is the mean profit.
Okay.
You must pay it.
Okay.
You must pay it. However, some landlords would be ejecting the tenant because his intention is to increase the rent.
Okay.
And because the sitting tenant is either unwilling or the landlord feels he won't be able to pay the new rate of rent that he is going to be demanding.
Yes.
He will say, no, I don't want this rent. I don't want this money that you're paying.
Okay.
Okay, because when that tenant leaves, the new tenant that is coming in, the landlord will tell him what new rate he wants to.
And he will start from there.
Yes, and then the new tenant usually will not have any problems with that. But the old tenant will want to argue, will want to resist the increase and all of that.
Okay.
So, mean profits, yes, like I said, it's usually how much you were paying as rent. But it doesn't have to be so.
Okay.
The landlord could say, okay, fine. If you want to stay, if you want to remain,
yes,
this is my new rent.
Okay.
And if that is agreeable to the tenant and is able to pay, he pays that new rate. And the landlord may say, okay, I withdraw the notice to quit.
Okay.
And so a new contract is born.
Okay, we'll talk about rent increase, but just before we get on to that, we'll just take a short break. If you have not subscribed to our YouTube channel, it's your opportunity now. You need to click the subscription button, click the notification bell, give us a thumbs up, and then so that you can get all the videos fresh as we post them. We'll be right back. Take a short break. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Okay, sir. Now, if the landlord wants the tenant to leave the accommodation, you have said he serves him notice. Before the landlord can, okay, some landlords will actually just think, look, instead of me serving you notice, sometimes they tell you you have to leave, and when you don't leave, they come and add an extra padlock so you can't access the property. Or some will disconnect the electricity, some will remove the roof, or some will just downright make life unbearable for the tenant until the tenant on his own say, look, I don't want problem. Or some will get the police involved, and then the police will ask, when are you leaving? You are a troublesome tenant. Sometimes they will accuse the tenant of a threat to life. Say, he threatened to kill me. So in the course of police investigating, he said, I don't want him in my house again so that he will not kill me. Now, are those lawful ways to recover possession?
No, they are not only just unlawful, they amount to crimes. In fact, the recovery of residential premises law, in fact, all recovery of premises laws have that provision. Because a tenant, once he is a tenant, properly so called under the law, is entitled to live and occupy the premises in peace. The fact that you are a landlord does not entitle you to enter into that premises without the consent of the tenant.
Okay.
The house belongs to you, right?
Yeah.
The tenant is occupying just one room in your house.
Right.
But for so long as his tenancy subsists, you must seek the tenant's consent to enter into his room.
So those landlords who just, even when the tenant is not at home, they just open the door because they have an extra key and then look around.
That is not only trespass, for which the tenant can recover substantial damages against the landlord.
Against the landlord?
Yes. You can recover damages for that trespass.
Okay.
Because he is in possession. And the law of trespass protects possession.
Okay. Not ownership.
No.
Okay.
It protects possession, not ownership.
Not ownership, strict to sense.
Now, if the landlord gets that audacious to do some of those things you listed, like they remove the roofs, or they disconnect the electricity, or disconnect water supply, because it's there in the statute. That is a crime.
It's a crime.
It's a crime.
So the landlord can actually be prosecuted for that.
And jailed.
And jailed.
Yes.
For removing the roof.
Yes.
Or cutting electricity.
Yes. Once a
Or
landlord,
adding extra padlock.
exactly, a landlord who does that commits a crime. If the tenant knows how to go about it,
Yes.
he should report the landlord to the police.
Okay.
If the police know their duty,
Yes.
which I doubt if today's Nigerian police actually know what they are supposed to do.
Well, they know.
If the police know their duty and they are prepared to do their duty, they should arrest the individual and charge him to court, prosecute him, and send him to jail. And I think we should be having that kind of thing happen more often.
So, well,
yeah, so that some landlords can behave themselves. The fact that they call you landlord
yes.
does not mean that you are lord over the tenant. At best, you are lord over your land.
Not over the tenant.
Yes, you are landlord, not tenant.
So you can't just behave anyhow.
Yes.
So okay, now, so the landlord cannot add double the padlock to lock the tenant out. He can't get boys to beat the tenant. He can't get the
landlord
police.
has no right to disturb the peaceful occupation of the tenant so long as he pays his rent.
So even if he's in arrears of rent, can the landlord come and, after all, you haven't paid me rent, it's my house, I come and put an extra padlock and stop you going?
The tenancy laws in this country are designed to protect the tenant.
Designed to protect the tenant.
Yes. So, at commencement of relationship,
Yes.
there is an agreement.
Yes.
That's why we say the relationship is a contractual one.
Yes.
But when that agreement falls apart, either because the tenant is unable to pay his rent,
Yes.
he ceases to be a tenant. The law steps in to protect him. So he becomes, instead of a contractual tenant that he has always been,
Yes.
he becomes a statutory tenant.
Wow.
A tenant that is protected by statute.
Wow.
So all those provisions in the statute,
Yes.
in the recovery of residential premises law, that he is entitled to notice to quit.
Yes.
And by the way, we haven't talked about the notice of owner's intention.
Yes, so I was just going to come to that.
Yes.
Maybe we should get to it right away, sir. The procedure before the landlord can go to court to recover
evict.
possession or evict a tenant.
Yes.
What are the things the landlord needs to do? Because all this we have said, tenant for tenant for tenant. What about for we landlords? We landlords. I hope we are the landlords. what do we need to do to get sometimes some tenants that give you a headache? He hasn't paid rent.
Very simple, simple really. It's just that most times by the time a landlord decides to eject a tenant,
Yes.
he's angry,
Yes.
he's emotional,
Yes.
and he's in a hurry. He wants the tenant to leave almost immediately.
Yes.
But that can't be possible most times because the law prescribes how long you must first serve the tenant a notice to quit. At the expiration of that notice to quit,
So the 7 days notice is a mandatory notice.
7 days notice of owner's intention.
Okay.
Not just 7 days notice, because there
Okay.
is another 7 days notice to quit,
Okay.
which a tenant at ease, or what is that term now?
Yeah, tenant at will.
Yes, tenant at will.
Okay.
Is entitled to.
Okay.
If you are a tenant at will, the
Yeah.
law requires that you be given a 7 days notice to quit,
Okay.
which will be followed by another 7 days notice of owner's intention to recover, to apply to court to recover possession.
Okay. So these are the two notices. So any landlord who wants to get a tenant out, you must give notice to quit of some sort.
Yes.
And 7 days notice of your intention to go to court. So you must let the tenant know, I'm going to court if you don't leave my house. Now, sir, after that.
And I should make this point,
Yes,
that the only way by which a landlord can get a tenant to give up possession is by obtaining a judgment of court granting him powers to recover that possession. In my days in office, I've seen lawyers who file just motions seeking for an order of the court to enable the landlord break open the premises occupied by a tenant on the excuse that the tenant has locked up the place and, run away, and they don't have, they don't know where he's gone to, and maybe he has not paid rent for very many months.
Yes.
There is no arrangement known to our laws by which you can recover possession of premises unless by first obtaining a judgment to that effect. So, if indeed it is true that a tenant has locked up premises and absconded, you still, as a landlord, must issue a notice to quit. Then you bring an application to court to enable you serve that notice to quit by pasting that notice to quit on the premises, so that the tenant can be said to have been given notice of that notice.
But to your knowledge, the tenant has already abandoned the premises.
Well, but the law must be complied with in terms of procedure, in terms of what you must do in order to recover possession. You must serve that notice to quit. After the expiration of that notice to quit, you must serve the 7 days notice of your intention to go to court.
So you must keep pasting this on the entrance
and
door.
You don't paste it at your will. You must seek leave of court for that pasting. The court would normally give you that leave as a matter of course. You now paste it. And when I was in office, if I make an order that you go and paste, I would usually also include an order that when you paste, take a photograph of the pasting and exhibit it in the affidavit of service and place it in my file. That is because the court wants to be sure that, like Caesar's wife, everything that the law says you must do was seen to be done. There is so much the court can do. Now, after you have done the pasting, you must now go into the witness box and prove your case and get judgment. After getting the judgment, you can now also apply to court to say, my lord, this person has locked up the place like we have always said, and we don't know where he is. Give us powers, give us leave to break open the premises so that we can properly recover. Then the court would usually give you leave to do so. And in giving you, making that order, the court will say you must go with the court belief, you must go with the police. And when they break the place open, whatever is found inside, an inventory of them must be taken and brought to court. That is the way to do it. But to say you bring a motion and ask courts to give you an order to go and break somebody's house just because you allege that the person has locked up the place and absconded, no, there is no. In fact, there are 2 Supreme Court judgments in that regard that forbids it very clearly. And then there is an old English case, I think that case was even decided by Lord Denning, that no such arrangement exists that any landlord can embark on self-help in recovering possession. So
no landlord can embark on self-help in recovering possession?
Never. No such arrangement.
Just closing question, sir. When a landlord, despite knowing all of this, despite hearing all of this, despite having heard you, landlord still takes it into his power to force tenant out. Can the tenant sue the landlord for trespass and claim compensation?
Yes. Yes. You see, it's not only even with landlord. You see, in our civilization, under our legal system, there is no arrangement that allows you to embark on self-help. To embark on physically do anything without the authorization of the courts. the first time I attended the law class, in my days in the Nigerian Institute of Journalism, I had the privilege of having been taught by the late Dr. Olu Onaguruwa. And when he was teaching us
Olu Onaguruwa,
yes, I remember him giving the example that, because in those days it was a common thing for policemen to jump into your car, that they are arresting you for having infringed upon one traffic offense on the other. And Dr. Onaguruwa said that a policeman jumps into your car without your consent amounts to trespass.
Wow.
Unless you allow him to get into your car, that is trespass. And of course, the other example, which was more interesting, is that you don't kiss a lady without her permission.
Oh.
Yes, you give a lady a peck without her, but that is trespass.
That's trespass to person.
Yes.
Okay.
So, I mean, if that is the position of the law on trespass, how much more when you introduce force into moving somebody from where he otherwise is entitled to be? I mean, that is criminal. No landlord should do that. In fact, nobody should do anything like that. It should not. Our civilization has gone far beyond that kind of level where people do things by force. Granted that I know that because of our long spell with military people as our leaders, most Nigerians tend to think that to achieve whatever you want to achieve, you have to be a bit violent.
Okay.
It's either you're being physically violent or you're being outrightly crude in your choice of words by being violent, being abusive and such things.
And demeaning to the other party.
But our civilization, does not encourage that kind of thing. We're entitled to be civil in all our dealings.
But court procedures take a long time to recover possession, sometimes 2-3 years. Your closing remarks, sir.
You may be right that it could take a long time to get to judgment, but that is your country for you. I mean, there is a lot we need to still do to ensure that judicial processes move faster. Than we presently have. There's really no reason why an action for recovery of premises should take more than 3 months. 3 months. But the problems are not only with landlord and tenants, it's in our court system generally. You people who are there should create more courts.
I'm not there, sir. I'm just a presenter of show.
I agree with you. I'm sure your viewers would also agree with you, but you know that you and I, we know ourselves. So I know what I'm talking about. But the point I'm making is that this country still has a lot to do with our administration of justice system generally. The other day, His Excellency, the President of this country, said he does not see any reason why any case should go on in court, even if it goes up to the Supreme Court, for more than 15 months.
Oh.
Yes.
He said that?
He said so.
Okay. He must be coming from the UK.
Between 12 months and 15 months. And it is achievable.
It's achievable.
I mean, once the will is there, it can be done.
Yes, can be done.
But why are we where we are? I think we're just a lazy nation. And I say lazy nation because even the lawyers are not as diligent as they should be most times.
Well,
in my days,
the clients don't pay, sir.
Yes,
they don't pay.
No, well, that's another matter altogether. But I know that while I sat as judge, I sometimes almost went on my knees asking counsel to please go on with this case.
Come and do your case.
Go on with this case.
Come and do your case.
Okay, but for their own reasons, they just want to adjourn.
Okay, well, now all these books that you have, some of our viewers may want some copies. Where can they buy if they want to buy? I mean, let's go to the market, as they say. Let's sell some books. So if somebody wants to buy area customary code guides in Nigeria. So where can we get copies, sir? Sorry to interrupt.
Incidentally, they are all sold out.
Oh, they are all sold out.
The only place you can
but I thought you had some on Amazon.
Yes, the only place you can get any of my books, and all of my books now, is on Amazon.
Amazon.
All right. As many copies as you want, Amazon will print and post to you. You pay online using your ATM.
So anyone wants books can go online.
Just go on www.amazon.com. Type the title of the book or type my name, and then all my books will come out.
And then you can pick the one you want to buy.
Yes, you pay. You buy it from your bedroom. You use your ATM on your system. You pay. Your bank will do the conversion for you.
Yes.
You provide an address. Amazon will print and post to you.
Wow. So you can get some of his books from Amazon.com. Learned author, learned mind, learned journalist, learned writer, learned community leader, learned barrister at law, based in Ole in Delta State. I want to thank you again for coming on the show, and I hope you come again some other time.
I'm very grateful. It's been my pleasure being part of this wonderful thing you are doing here.
Thank you, sir. And if you have not subscribed again, please do subscribe. If you have questions or comments, leave your comments on the comment section. Ask your questions there. Or there's a phone number you can call the producers of Pinnacle TV, producers of the Law Show on Pinnacle TV, and I'm sure they will be able to assist you if you have questions or if you want to get in touch with him to ask some questions. So that's how it's been today. See you next time. Bye.